Hey, 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 beautiful people. Hey, sexy people. Y'all know we got to keep that vibe going a little bit. What's up, sexy people? Hey, welcome to another episode of Nights with Nicci. I see you, TikTok. I see you, LinkedIn. I see you, Facebook. I see you, X. Got it right today. I see you, Instagram. Or do I see you, Instagram? Hold on, let me make sure my Instagram family coming up in here. Okay, there we go. Instagram family's coming up in here. Hi, everybody. Hello, 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 and welcome, welcome, welcome to another episode of the realest digital nighttime, honey, show, Nights with Nicci. Hey, 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 let's give it up for ourselves. Let's give it up for us for showing up. All right, we muted again. Hold on. Let's do this the right way, baby. Because you know we got to make sure that our applause is heard and felt all throughout the land. Okay, that's a little more like it. Ladies and gentlemen, stop this. Hold on. We got too much going on. Okay. Welcome to Nights with Nicci. We finally got it right. Hello, everybody. Thank you guys for joining me on this very special episode. I almost did not make it tonight because we had a little bit, grandbaby got a little asthma. So we had a little situation. We didn't know if we was going to have to, kick rocks up out of here. I'm still monitoring him. So instead of being my normal long-winded self tonight, I'm going to, stick to the script. No pun intended. You guys, tonight is a special night. I am, and if you see anything dripping down the side of my face, just let me know in the chat because my curls, still ain't dry. My hair holds water, honey. I got the thickest hair ever. When I say thick hair, thick hair, and it holds water. So it might get to dripping because I had to do a real quick 1-2 updo situation. But thank you guys for coming in and hanging out with me tonight. This is a very special episode of Nights with Nicci. And if you are watching me on WIRF.TV YouTube, please do me a favor and hit the like button so we can bring a few more people into this chat. Please, wherever you're watching me. What up, Brooklyn? I see you in the house. I see you, Costa Rica. Niceness. Okay, Costa Rica. I see you. I see you, Bert, on TikTok. I see you, Be For Real, on TikTok. I see you, Deborah Gooden, on TikTok. I see that was my sister's name. I see you, Tommy, on TikTok. I see you, Rebecca. I see you, The Mortgage Bay. I see y'all, and I appreciate all of your hearts. Chevy Nova says, since you're a writer and producer, you should do a documentary on surviving government officials or victims of our words or sexual assault, harassment. Oh, wow. Yeah. Well, you guys know I have a passion for sharing stories yep, I see you guys. Thank you for the hearts. I have a passion for sharing stories of victims of all sorts of unfortunate circumstances. So I mentioned it last night on my live. I mentioned it as many times as I can. One of the reasons why I'm so passionate about victims of SA is because, I have several members of my family, including my mother, who was a victim of SA. That is the reason why it was so much fun and so cool for me to spend the time that I did at the Day on the Hill with my sorority, Sigma Gamma Rho Sorority Incorporated. Hello. Yep. It was a wonderful experience for me to be there, for me to be able to advocate on behalf of the Healthy Partnerships for Survivors Act. Went to Bernie Sanders' office, went to a few folks' office, y'all. And we knocked on some doors and we marched through some hallways and it felt great. It felt really, really good. As a matter of fact, you guys, I want to get into this real quick with y'all. TikTok and Twitter, I'm sorry, not Twitter, Instagram, you will probably not be able to see this. But before I get into this writ, I want to share something that is really important and something that we're super passionate about. I'm going to read it, you guys, and you'll be able to see it if you go over to my page. Hey, Shayla, I see you. Hey, All Things TNT. Hey, Nurses Fee. Hey, complex anxiety. Thank you for the heart. Thank you very much. Let me come in here and say hi and do some housekeeping over here. What's up? I see you, J Perry TV, JL Perry TV. Hey, Gag for your life. Thank you very much. And that's a great point. Make sure that you like, share, subscribe, and also hit the notification button. Thank you, Gag for your life, for reminding me that. Oh my goodness. Hey, Cordell Capone says, wishing you the best tomorrow. I hope it's good luck. Yep, everybody. I really appreciate you guys for the love that you're showing me and the, sticking this thing out. As a matter of fact, I'm going to go on ahead and read this now. Well, I'll wait until a couple more people get in the room because I want to make sure that everybody is able to hear. I wrote a little letter to y'all that I want to share with all of you because I really appreciate y'all for, you don't know what this feels like until you're actually in this mess. And mess is the best way that I can describe it. It is truly, indeed, a mess in real life. But we are at the tail end of this mess. So what's going to happen is one of three things. These are the things that can happen well, first, let me do this. Let me get this housekeeping out of the way, because this is very important. So one of the things that I learned through this process of this litigation is that sometimes the judicial system doesn't work out for you. No matter how well you think your case reads, no matter how truthful you are in your claim, as I have been amplifying all week, for the last 5 years, you guys, actually, sometimes you just don't get what you feel is justice, right? It is just how the system works. However, there are alternate ways to make change. So I'm praying to God that tomorrow, this thing, I pray that the 3 things that they will do, or the 4 things, that they can do. So I feel a little drippy drip. Y'all supposed to be telling me I got a little drippy drip. My hair is dripping. One of the things they could do is in a perfect world, what we really want the Supreme Court to do is we want them to grant my writ of certiorari. That means that I go forward, they hear my case, and then my case goes back to trial. I know. It's a long journey, y'all. It's a long journey. Them saying I go forward does not mean that I win my case. Them saying I go forward means that I win the opportunity to go before them, do a hearing, and explain why I deserve a trial in my case. So it's a long journey even after tomorrow, right? Most people think, and that's why I thought it was really important for me to have this live tonight, because who knows what kind of mood I'm gonna be in tomorrow. I ain't even gonna hold y'all up. It is just exhausting. The whole process has been exhausting, and I'm proud of my family and I for holding it together for as long as we have been able to, because this shit is, not for the faint of heart. But the 4 things that can happen in this situation, there are probably more things that can happen than just 4, but the 4 main things that occur in situations like this. Thing number 1 is they grant, which means I can go forward. Thing number 2 is they deny, which means that it is over. However, let me just say this real quick, and I'm going to say this tonight so y'all don't be surprised, right? That is not technically my last opportunity, okay? That is not technically the last opportunity that I have. I actually have an opportunity, even if they deny it, to go and ask them to reconsider it based on new evidence. And I do have some new evidence. I believe we have some new evidence. We don't want to talk about what that new evidence is right now because, but we discovered it shortly, not too long ago, and we discovered it after I had already filed my writ of certiorari with the court. So if they say no and deny me tomorrow, then we do have plans to introduce this new information that we've discovered, something that transpired after all of this. And hopefully that will be enough to convince them to reconsider. Reconsideration is very, very, very difficult. If you think getting the writ of certiorari on the merits granted is hard, that is probably 10 to 15 times as hard. But we believe that the additional information that we have will give us the opportunity to at least say, hey, we'll take a look at this too, because we weren't able to include that. So it's 11:11. Thank you, Lord God, for all the wonderful blessings that you've given me, Jesus. Lord God, bless the hearts and minds of the justices, Lord God. When we find out what their decision is tomorrow, let it be granted, Lord God. Let them grant this writ of certiorari, dear Jesus, as a way to protect creatives, underfunded creatives from corporate entities, Lord God, as a way to prove that everybody deserves the right to a fair trial. Everybody deserves to have their evidence heard, Jesus. Let the justices, please, Lord God, approve my writ of certiorari, grant my writ of certiorari, and allow me to argue my case before them. In your mighty name we pray, amen. That's a good sign, 11:11, right before. Last 11:11 before the decision is made. So, and if y'all don't know how real I am with this 11:11, don't get it twisted. We real about it over here. You understand? It's a whole lifestyle thing. Just angel numbers, the angel numbers, angel numbers. Thank you, Mommy, Debbie, Daddy, Maxie, Angie. All of my ancestors, all of those who have gone on to become ancestors. Anyway, guys, so I want to run this by you guys real quick, because this is definitely, it is not over. And even if, okay, I said the 4 things. I gave you 2 scenarios. Scenario 1, grant. Scenario 2, deny. Scenario 3 is what is called a call for a response, or a CFR. What a CFR means is that at least one of the Supreme Court justices felt like this was worth asking Lionsgate and Katori Hall's attorneys, which are 2 separate entities, to file a response. Now, they filed what is called a waiver of a right to respond, right? So I filed my writ of certiorari. They filed a waiver. Usually when people file waivers, that means, I see somebody named Helen. Oh my God. Faye and Helen. Oh my God. What is that? Love Faye and Helen. Wow. I'm sorry, guys, but Faye is my most delicious favorite. Well, I don't have a favorite auntie. I love them all. But Auntie Faye is my mother's sister, and Helen is my mother's name. So for Love, Faye, and Helen, oh my God, thank you. Thank you. What a positive sign. I just waved to you. Love, Faye, and Helen. Our Auntie Faye, and my mama's name is Helen. Wow. Okay, now if somebody come up in here with the name Maxie, then we're going to have to just start shouting up in this BI. You understand? Hello, Rhythm and Blues Society. Peace to you as well. So a call for a response would be another positive thing, right? If the Supreme Court does what is called a call for a response, that means that they are asking Lionsgate, no, you're not just going to waive your right to respond. We need to hear from you. So that is a really positive sign as well, a call for response. So if it says CFR or grant, we're in good shape. The other thing that can happen is something called a hold or a relisting, right? And a hold and a relisting just means we need a little bit more time to digest this. We need a little bit more time to look into this. There is some interest there. Thank you. I appreciate that. There is some interest there, but we just need to verify a few more things here and there, right? So the 4 things that can happen tomorrow at 9:30, they're going to, and here's the thing, you guys, the decision has been made since last Monday, September 29th. I believe, I don't know for sure, but the way that it typically works is on the 29th, they all come together in a closed door conference. And during that closed door conference, they discuss the cases on the docket from the summer list. Jelaine Maxwell was actually discussed on the same day as my case too. So that's just to show you kind of how serious the situation is. Now, you guys, I'm going to read the writ because I want it to always be here and available for everybody to go back to and to reference. All of this, me sort of just documenting and sharing. Of course, there is a doc film, which is going to have a lot of footage that you guys have never seen. As much as I'm on this here, WRF.TV YouTube channel, please hit like, share, subscribe. And as much as I'm out here on these TikTok and Instagram streets, y'all probably feel like we've seen it all, we've heard it all. But there is plenty left in this story. And I want to just say I really appreciate y'all, because I know that it becomes a little redundant. I know that it becomes a bit much. And I know that there are people out here who really love the show P Valley and don't understand why it's not back on, right? So I want to ramble this whole time because I'm gonna get up extra early tomorrow for my prayer and my meditation and just, but yeah. What was I? Oh, 4 things. CFR, deny, grant, hold. We're hoping for a grant. At the very least, the CFR. And we'll take a hold as well. Okay, guys. So I just want to say real quick, I want to share this with you all before I get into the writ. This is super important. So when I went to Washington, D.C., and I realized how easy it is to just lend my voice and my likeness and my name, to really important causes. And I'm so grateful to the org for allowing me to do that. It's really interesting because we have been working on through the process of this case. You just never know. God will bring you to something and you think that it's all about fighting this case and winning this case. And you discover that maybe God is just trying to wake up, a sleeping giant, for lack of a better word, in you, and just try to encourage you to think beyond just myself and the things that I want and the things I desire for myself and my family and what would help, people, on a much bigger scale. So legislation, lobbying for creatives, not into no politics, because like I said, I don't believe I have the capacity for it. Never say never. But right now, my passion is just using my platform and using my voice because I've been doing that all along anyway. So it wouldn't be such a big deal for me to become a lobbyist or, advocate. I like that word better. I'm sorry. I think this means the same thing, sort of, kind of, but an advocate of sorts. So one of the things that my team and I have been working on very quietly, and maybe not so quietly on some levels, you hear me get on here and complain a lot about what's going on in the entertainment industry. You hear me complain a lot about not having ownership. You hear me complain about not having equity, but complaining is just not enough, right? Obviously nobody hears you when you just complain. I'm a person who believes, actions speak louder. There you go. I might sing for y'all tonight if y'all stick around until the end of this writ. In fact, I will for sure sing for y'all if y'all stick around till the end of this writ. But while we're waiting for a few more people to come in here while I start reading the writ that I filed, I'm so proud. How about a round of applause for me? I want to thank me. What's the thing? I want to thank me, baby. I'm just grateful. I'm just really, really grateful. I know I'm going to be emotional tomorrow. I don't know if I'm going to be pissed off or I'm going to be jumping for joy, but either way, I will be proud of myself. My crown will not be tilted at all. My crown will sit straight and I will get my ass in gear, right? One of the things I'm going to get in gear and do is this here. All right, you guys, I'm going to go through these slides. It ain't that many of them, but I want y'all to roll with me and bear with me. So, of course, we at From the Bottom Up Foundation, which is my 501c3 nonprofit organization, have launched a program, Creatives Equality Awareness Month, where we are championing equity and rights for BIPOC creatives, you guys. Our mission is policy, education, and equity. Our campaign aims to champion equality, to promote intellectual property rights for BIPOC creatives in the entertainment industry, ensuring that they receive their equitable resources, funding, and support that they deserve. Our key objectives are to raise awareness of equity issues, advocate for legal access improvements, and support BIPOC creatives' unique narratives. Our campaign goals are to build a coalition of supporters and establish resources for financial aid and legal support services, create workshops for intellectual property education. You guys, I'm really excited about talking to the young people about how to really protect their creativity and their rights, right? We want to safeguard creativity through rights. We want to protect original works that is essential for creative expression. Intellectual property rights empower creatives to maintain ownership of their work. We want to promote fair compensation, ensuring equitable earnings. Financial equity ensures that BIPOC creatives receive fair compensation for their contributions. Access to legal resources, navigating legal landscapes. Legal access is crucial for underrepresented artists to protect their rights effectively. Alongside our funding initiatives, the coalition will introduce a legislative platform called the Creatives Partnership Act, you guys, a first of its kind advocacy framework that demands fair partnerships between creators and the companies that profit from our work. We are, I went slide too fast. I'm sorry. Slide 5. There we go. Championing financial equity. We want fair pay, equitable opportunities, ensuring that they get what they deserve. Creators earn what they deserve. We want transparency. We want open communication, promoting clarity in financial agreements for all. That is so important. If you only knew how many artists and creatives have no idea how much money they have actually made for these companies. Transparency is so key. We want supportive networks, collaborative communities, and building strong alliances to uplift each other. We want legal resources, accessible aid, and provide guidance and support for creatives in need. Historical underrepresentation of BIPOC in entertainment, the exclusion from foundations of industry power. We have erasure in early cinema. BIPOC creators are often excluded, typecast, or relegated to harmful stereotypes in Hollywood's formative years. They always had barriers to authorship. Systemic racism blocked access to directing, producing, and writing roles, entrenching white creative control. I'm sorry, it is what it is. Not sorry. And long-standing ripple effects. The industry's structural roots of exclusion continue to impact opportunities and visibility today. We almost there, you guys. The current industry disparities. Quantifying inequity in representation and leadership. Underrepresentation on screen. BIPOC actors comprise less than 30% of top film roles, despite being 40% of the U.S. population. Only 6% of Hollywood film directors and 8% of showrunners are Black, Latinx, or Indigenous, or Asian. That's a shame. That is pure leadership inequality. Of course, we already know about pay and credit gaps. BIPOC creatives earn significantly less and receive fewer production credits despite similar outputs. Stay with me, y'all. The systemic barriers to access and opportunity, structural hindrances faced by BIPOC creatives, funding discrimination. It's so hard to get funded. BIPOC-led projects receive disproportionately fewer green lights and lower production budgets. Gatekeeping networks. Industry access is often limited to elite circles where BIPOC creatives remain underrepresented. And bias in evaluation. Creative works by BIPOC artists is more likely to be overlooked, stereotyped, or deemed niche. Economic impact of marginalization, the financial cost of exclusion in creative industries, the loss to economic potential, excluding BIPOC talent from industry leadership, and funding forfeits billions of untapped creative revenue. The creator economy is worth $250 billion right now, you guys. That should tell you all you need to know. Inequitable funding flows, white-led projects receive disproportionate share of investment, distribution, and marketing dollars, and there is an audience disconnect. Ignoring BIPOC voices alienates diverse audiences, limiting, you guys, their market reach and cultural resonance. So you can see more of that brief on fromthebottomupfoundation.org. I'm super proud of our team for putting that together, because what it says is that we are not just going to complain about the lack of equity and the lack of equality in this industry, but we're actually going to do something about it. And we're going to go, hopefully, very, very soon with an amazing group of people and talk to our congressmen, our congresswomen, our senators, our representatives, find other people who will help advocate. That is the Creatives Partnership Act. And basically, in a nutshell, all we're asking for is what we deserve, our basic civil and human rights. Okay, guys, so we are about to, I don't know if y'all heard me, right? We are about to go into, that's more like it, this writ of certiorari. Y'all, this was such a long time coming. my mom and my sister, I promised my sister before she passed away, I would continue to go forward. And I did that. I was watching last night. I've been in the rabbit hole, you guys. I have not been sleeping very well because this is just, imagine you're actually waiting for the court to determine whether or not you deserve the right to go forward and you deserve to be heard in a trial. And it's a really big deal. I'm so proud of myself for sticking this thing out. I'm so proud of myself, and I'm so proud of each and every one of you. And I want to read a little letter that I wrote to you all, to all of you fabulous people, before I get into this writ. I want to sincerely thank every one of you who has walked this 5-year journey towards creative equality with me. This fight, though one of the most public and painful litigations of my life, has been filled with more lows and highs, more no's and yeses, and the heavy reality of what happens when you dare to speak your truth. Tomorrow, in just a few hours, the Supreme Court of the United States has a chance to stand with the little guy, y'all. To say that underfunded plaintiffs deserve a jury trial, expert testimony, and freedom from the crippling fear of fee shifting that keeps so many of us from fighting. Shifting the fees over to the plaintiff is not okay. Charging my family millions of dollars in legal fees because you want to deter other people from bringing frivolous cases into your courtroom is just not okay. How's it possible that Hollywood has been right in 99% of all copyright cases? Denying this writ would affirm the very imbalance that allows billion-dollar corporations to silence those who create the stories that they profit from. The creator economy is worth $250 billion and growing, yet without balance, access, protection, most creators will never share in the wealth that they help to build. Tonight, in anticipation of tomorrow's decision, I'll be reading the Writ of Certiorari, which means to know for sure. I prepared this writ alone as a pro se litigant after I could no longer afford counsel. I'm proud of it. I'm grateful for this moment. And I understand that my chances are very slim. But I want anyone listening to know this. Fight anyway. Fight anyway. Fight when you broke. Fight when you're tired. Fight when you're grieving. Fight when you're scared. Because purpose does not pause for pain, period. You cannot grow weary. Whatever happens tomorrow, my crown won't tilt, baby. And it damn sure won't fall off. It will continue to cover my mind, my body, my spirit. The spirit of a warrior. One who knows that content is queen. And trust me, this queen has a queendom full of some content. And I can't wait to share it with you all. So welcome to Nights with Nicci. I'm going to get into this writ of certiorari that I did all by myself. That's in the Supreme Court of the United States of America. Okay, guys. So let's get into it. This is in the court of the Supreme Court. And you guys, I'm sorry if you're on TikTok and I think YouTube. Fight anyway. Hey, Pam, credible. Yes, I see you, Pam. Fight anyway. That part. No matter what, fight any doggone way. Hey, everybody. I see you guys. Okay. Y'all know I can very easily get distracted up in here and I start amen cornering y'all. And thank you, Pam. Thank you so much. Thank you, thank you, thank you. All right, guys, so I'm going to get into reading this. We done read the Diddy case. We done read everybody else's case. Why not get into this writ of certiorari with the Supreme Court of the United States? Okay, and yes, I am using the fact that I am Dr. Nicci Gilbert Daniels. I worked hard for this doctor's degree in honorary doctorate in humanitarianism, so I'm going to wear it well, especially when I'm filing something with the Supreme Court. I just need them to know. I mean, I got the little honorary curate, the HC, but whatever. Here we go. I'm going to try to read this and just read it through. There is so much of it that I'm not going to read all of the appendix, right? Because we have quite a few, but I will mention this. One very positive note I got back from the court is they asked me for something called a supplemental appendix, which is a side-by-side comparison of my charts, because I could not do a digital. When you file pro se, you can't do it digitally. You have to do it hard copy. So I had to actually print books and a whole bunch of stuff. But anyway, here we go. This is in petition for writ of certiorari to the United States Court of Appeals for the Ninth Circuit. First thing you have to do when you're doing a writ of certiorari in the Supreme Court of the United States, who knows, somebody else might pick up the baton and come after me. You have to present questions to the court, right? They're not just going to relitigate my case. Okay, they're not here to go through and decide what looks like what looks like another. You have to find questions that are much bigger than just you and that impact way more people than just you. So the questions that I presented in my case, I'm gonna move this over just a smidge, you guys. Hold on so I can see the whole thing. Cause trying to cover up my face here. Don't want to do that. Okay. Here we go. Can y'all see that? I hope y'all can see that. I know you guys can't see it, but y'all can hear it. Questions presented. Question number 1, substantial similarity and summary judgment. Does the Ninth Circuit's application of the extrinsic test and its requirement of striking similarity conflict with other circuits or Supreme Court precedent? And did the lower courts err in granting summary judgment by finding no substantial similarity as a matter of law? Let me translate it for y'all real quick. So basically what we're asking is there is something called an extrinsic test and an intrinsic test. And that test is applied differently in various circuits. The circuit court is where the appeals happen. The district court is where the initial claim occurs, right? So the question is whether or not the lower courts, which are the district court and the appeals court, whether they made a mistake. That's what err means, or, whether they made a mistake by deciding summary judgment. Summary judgment basically means that you don't go to trial. There's nothing to see here. Get it out of here, right? Typically, that is, a tactic that is used to get cases dismissed and thrown out. So it's a question of the court examining whether or not their extrinsic test, which for my case, it went from being substantial similarity to needing to be striking similarity, right? So there's a question there. Another question, expert evidence in copyright infringement, whether the Ninth Circuit erred in affirming the exclusion of petitioner's expert report and declaration offered to highlight substantial similarities between the works at issue, thus depriving petitioner, I will be the petitioner, of critical specialized analysis and raising due process concerns in the adjudication of complex copyright claims. So in a nutshell, by you guys throwing out my expert report, by the judge becoming or acting as a trier of fact, expert testimony has been a big topic of conversation in these courts, right? In the Skidmore case, the judges said, even if the expert is the worst expert ever, we have to consider the expert's report. The expert helps us in triers of fact understand what the case is about easier, right? So in other cases, the expert report has been very instrumental, very important. But for some reason, in the case of Gilbert Daniels versus Lionsgate, the expert report was not only not important, but it was completely thrown out. So there is what I would consider, and a lot would consider, a split, right, in the circuits, right? Because certain courts use certain ways of determining whether the expert report matters, whether or not summary judgment can be thrown out based on the expert reports being thrown out and whatnot. Again, I am not a lawyer. I am someone who knows my case backwards, forwards, and inside out. And as a result of me just wanting to be in the know, I watched every appeals video. I read so many other people's cases. So I have a lot of information in this brain of mine as it relates to copyright and what's happened in the past and how I can help myself. Because, like I said, I couldn't afford a lawyer, so I did this myself. It's also 111 pages, which is another one of my lucky numbers. That's Maxie's birthday, 111. All right. Parties to proceedings, it just basically, that's nothing. That's just basically showing it as me and Katori, and that's related. Okay, so I'm going to show you guys this real quick. It's sort of irrelevant, but I'm showing the table of contents. They're very specific about the font that you use at the Supreme Court, the spacing that you use at the Supreme Court, the headings, and I probably still made some mistakes. I still think for a pro se litigant, I did a pretty good job, and I definitely side by side everything. But they want to be able to look at the column and go and find it in the appendix. In the table of contents. Okay. These are the appendix that I mentioned that I'm not going to get into too deep with you guys. Appendix A is the order from the Ninth Circuit. You cannot get to the Supreme Court unless you have been denied everywhere else, right? Like my Sora Fantasia said, sometimes you got to lose to win. The only way you get into the Supreme Court is if you lose in all the lower courts. Okay. So I lost in the district court. I lost in the appeals court. And these are the appendix that basically show and explain what those things are, right? There's an appendix A, which is the Ninth Circuit. There's an appendix B, which is the summary judgment from Judge Wilson in the district court. And then there's appendix C. And then a supplemental appendix is what they asked me to send them separately, which is a good sign. It's usually a boon for your case if the Supreme Court asks for a supplemental appendix. So that's kind of one of those things I'm holding on to as just a halfway decent sign, right? A very good sign, actually. Okay, so then table of authorities, you guys. This is school now, so if y'all gonna be bored with a little education, I'm just letting y'all know this is important, just in case anybody else decides that they got to go and holler at these people at the Supreme Court. And also, you guys see how it is the indentation, the columns. Okay, boom. They're very specific. So these table of authorities is basically all the cases that I reference in my writ. So anywhere that I went and pulled information to support my argument, I have to let them know what pages it's on, and it has to coincide. These people do not play. They're very specific. Okay, so this is my opening statement for a writ of certiorari. Not everybody has one. I saw a few people that did, so I felt like it was very important for me to make an opening statement. My petition for a writ, the case rages, this is sort of the first explanation of why the judges should consider it, right? I'm a writer in real life. I got some advice and some help here and there, but, just FYI. This case raises urgent constitutional and doctrinal concerns about using expert testimony, the proper limits of judicial discretion at summary judgment, and the fundamental right to a jury in a complex copyright dispute. The Ninth Circuit affirmed and granted summary judgment to respondents, that's the defendants, stars, effectively terminating the case without allowing a jury to evaluate whether critical evidence of substantial similarity between the parties works. In doing so, the lower courts disregarded the standards articulated in and this court's ruling in Anderson versus Liberty, which cautioned the non-movement's evidence is to be believed, and all justifiable inferences are to be drawn in his favor. Credibility determinations, weighing the evidence, and drawing legitimate inferences from the facts are jury functions, not those of a judge. Despite offering a professional, independently conducted analysis based on established industry methodologies, the petitioner, the petitioner's expert, was dismissed as merely parroting the plaintiff. This exclusion ignored the reality that experts often corroborate a plaintiff's claims precisely because they analyze the same creative material through a trained lens. And now, remember, you guys, I said I watched just about every appeal, right? So thankfully, it came in handy when I wanted to reference it in this writ. As the Ninth Circuit itself recognized in Zindel versus Fox Searchlight Pictures, additional evidence, including expert testimony, would aid in the objective literary analysis needed to determine the extent and qualitative importance of the similarities, particularly the plausibly alleged shared plot sequence. Indeed, as Judge Kim McLean Wardlaw remarked during oral arguments in Zindel. So I watched the oral argument case. If you guys have a chance, after me reading this, Rich would be like, okay, we've had enough of your case already. But if you have a chance, take a look. There's an AI breakdown. You can actually see my oral hearing with the appeals court online. If you go to the Ninth Circuit's YouTube channel, you will actually see my lawyer arguing this, right? But one of the things I pulled and I included in my writ was this statement from Ninth Circuit judge. Now, I was in the Ninth Circuit as well. I just did not have this judge. I didn't have any of these judges that seemed to see things the way my team and I saw them. Unfortunately, I didn't get those judges. But anyway, Judge Clem McCain Warlaw remarked during oral arguments, I think it's kind of hubris for a district court judge to think that they have enough knowledge and basis in film and theory, things people go to school for, USC, UCLA, to learn all about, that they can decide this on just a dismissal stage, except in rare cases where it's just obviously so frivolous. The exclusion of this expert testimony gutted the petitioner's case and denied her the opportunity to have disputed facts evaluated by a jury. Compounding this error, the panel applied the Ninth Circuit's rigid extrinsic test, filtering out protectable elements and requiring a striking similarity in the arrangement of those that remained, a standard that diverges sharply from the more flexible jury-centric approaches followed in other circuits. This fractured and inconsistent landscape of copyright adjudication requires this court's intervention. Certiorari is necessary to resolve this conflict, reaffirm the jury's constitutional role in weighing expert testimony and factual disputes, and restore due process protections to under-resourced creators seeking justice under the Copyright Act of 1976. Okay? So, I'm messing with this thing a little bit too much. Opinions below is another area that you guys don't really have to hear or too much about. It's just housekeeping. And basically what it says is it pulls information and context, right, from other cases. So here it says a witness who is qualified as an expert may testify in the form of an opinion or otherwise. The expert's scientific, technical, or other specialized knowledge will help a trier of fact understand the evidence to determine the fact at issue. So these things have been ruled in other cases, but for whatever reason, they were not applied to mine. Go figure. So then I have to go into a section where it says the statement of the case, right? That is the factual background. Petitioner is Dr. Nicole Gilbert Daniels, a playwright, producer, and recording artist. She created an original musical stage play and released works titled Soul Kitten's Cabaret. Soul Kitten's Cabaret consists of 2 stage play scripts, written in 2006, 2010. Actually, it was 2004 with the Writers Guild, but still 10 years before Katori. 12 years before Katori, and filmed the staged performances released online and DVD in 2011. The work center around African-American cabaret nightclub called Soul Kitten's Cabaret in Detroit, Michigan. They feature a troupe of female dancers and interpersonal business challenges they face. SKC's storyline incorporate themes of sisterhood, struggle, personal redemption, and faith, presented in a stage play format with periodic song and dance numbers. For example, in SKC, the club owner, Tata Burlesque, is a gay, gender-fluid man who inherited the club from his late partner, struggled to keep the venue afloat in the face of a takeover attempt by his partner's son. This homophobic antagonist harbors ill will towards Tata and plots to seize the club for a casino development. Throughout SKC, the characters must adhere to specific commandments, rules of the club, to retain their stake in the business, and the antagonist attempts to trick them into violations that would forfeit ownership. The tone of the petitioner's work blends entertainment with moral lessons, often evaluating characters through the lens of challenges and redemption. You guys, there's a bunch of legal ways to describe this because it can't just be an emotional story, more fact-based. So if it sounds a little, stringent, then, that's why. Respondents, who will be P Valley, Katori Hall, Lionsgate in this case, are companies and individuals involved in creating the television series P-Valley, a dramatic series that premiered on Starz Network in 2020. P-Valley is set in the fictional town of Mississippi at a strip club called The Pink. The club in the P-Valley is owned by character Uncle Clifford, a gender-fluid person who inherited the establishment from a family member. In the show, Clifford's grandmother. The series follows the dancers and staff at The Pink as they navigate personal struggles, crime, community pressures, and the central conflict in the first season of P-Valley involves efforts by an outside party who happens to also be a homophobic mayor and developers to purchase or foreclose on the club's property for a casino development. At the same time, Uncle Clifford fights to save P-Valley, has a gritty contemporary tone, emphasizing the harsh realities of its characters' lives, poverty, abuse, corruption, and survival. Spiritual and religious themes come up in P-Valley, and the character Patrice Woodbine, an overly religious mother of the lead dancers. The series is presented in episodes, an ensemble drama format. Petitioner's 2-hour musical stage production is performed on a live theater and did not have the large development budget of P-Valley, but the central story has the same beginning, the same middle, and the same end. Petitioner alleges, that would be me as a petitioner, that P-Valley is substantially based on or derived from Soul Kitten's Cabaret. She contends that the creators of P-Valley had access to her work. The petitioner left copies of her stage play and her derivative work, which was a dramatic spinoff, with Lionsgate executives when she pitched it to them as a drama series in 2013. Petitioner's stage play had been publicly performed and distributed in SKC since 2007. And numerous specific elements of P-Valley, its character settings, plot, and themes are strikingly similar to those in SKC. For example, both works feature a nightclub primarily featuring Black women exotic dancers. This LGBTQ club owner who inherited the venue from a loved one, a homophobic antagonist figure attempting to take over the club for a casino project, and supporting characters such as an older mentor figure among the dancers, a romantic subplot involving a club bouncer and protector, and a dancer whose very religious parents disapproves of the daughter's profession, and overarching storylines of the owner and performers banding together to save the club from closure. Petitioner asserts that these and other similarities exceed mere coincidence or generic concepts, especially given the uncommon overlap of an inherent storyline and an LGBTQ club owner protagonist in a cabaret setting. She maintains that P-Valley appropriated unique combinations and arrangements of these elements, making Soul Kitten's Cabaret an original protected work. Petitioners allege that her Soul Kitten's Cabaret, which works in a way that goes beyond generic tropes, amounting to appropriating her creative expression. So here is the procedural history of the case. On January 12th of 2022, through counsel at the time, petitioner, who was me, filed a copyright infringement action against respondents, Lionsgate. The suit was initially filed in Northern District of Georgia, but still it was later transferred to Central District of California because for the convenience of parties and witnesses, as P-Valley and respondents had strong connections to California upon the transfer. Respondents were ordered by the district court to file a motion for summary judgment, making the dismissal of copyright claims on the merits, right? So remember I said the judge ordered the defendants to file a motion for summary judgment, which for me felt like him being the referee telling the other players how to play the game. District court's decision in the Central District of California, respondents moved for summary judgment, arguing that P-Valley was not substantially similar to SKC as a matter of law, right? So as a matter of the laws that have been established, because of all the people who have lost, the 99% of plaintiffs who have lost, law becomes established, precedent becomes established as a result of those losses. So as a matter of the laws that have been established by all the people who have lost so far, as a matter of law, arguing that there's no substantial similarity. Respondents also moved to strike the expert's report and declaration submitted by petitioner's expert, Mr. Robert Aff, which compared the two works. The district court, Honorable Stephen Wilson, held a hearing on September 18, 2023, concerning the expert's evidence and other pretrial issues. After that hearing, the court granted respondents' motion to exclude the petitioner's expert and declaration. The court determined that the expert's analysis did not materially aid the court beyond the comparisons the petitioner herself had made, characterizing the report as merely reiterating generic similarities between the works. With the expert evidence excluded, the court evaluated substantial similarity in summary judgment. And on December 27, 2023, the district court issued an order granting summary judgment in favor of respondents and dismissing petitioner's copyright infringement claim. In a detailed memorandum, the court applied the Ninth Circuit's two-part test for substantial similarity, the extrinsic test, an objective comparison of specific elements, filtering out unprotectable content. So they're basically saying, if this is a restaurant, all the basic things that would occur in a restaurant, right, are unprotected because they're scenes of fare, or they would fall in the space of, like, we know it's going to be a coffee mug, we know it's going to be a table and some chairs, and somebody might eat too much or drink too much, right? The comparison of the work's overall concept and feel, the court concluded that after filtering out elements it deemed unprotectable, such as general ideas of storyline in the strip club environment, stock characters, and commonplace scenarios, the remaining similarities between SKC and P-Valley were insufficient for any reasonable juror to find substantial similarity in protected expression. The court's order noted numerous differences between the works. For instance, the club owner in SKC, Tata, is a gay man motivated by preserving his deceased lover's legacy, whereas in P-Valley, the owner, Uncle Clifford, is a non-binary person facing financial struggles and trying to preserve his grandmother's legacy. The district court also pointed out that a specific plot devices in P-Valley, such as a looming casino and political corruption, either didn't appear in SKC or were only mentioned a few times and were superficially similar to the petitioner's story elements, which is not true. In sum, the district judge held that the petitioner failed the extrinsic test because the overlap between the works related primarily to scenes of fare, which is a word they came up with to describe this. And one of the appeals court judges, I believe it was Judge Paez, was like, what is scenes of fare anyway? Like, what does that even mean? Like, what does that mean? Because it was just created to help, in my opinion, get rid of cases. But anyway, superficially, scenes of fare and other unprotectable ideas, thus no triable issues existed on substantial similarity. Given that conclusion, the court did not conduct an intrinsic test analysis for a jury and enter judgment for respondents. So in other words, what this is saying in short is that because they did not feel like it was similar enough, the fact that I left my script with them, whatever they said during the deposition, the fact that I have proof and evidence that Katori was talking to some people or one of Katori's people was talking to some people on my team, none of that stuff was able to be used or included in the case because they felt like it wasn't similar enough. So why waste our time going through the intrinsic test, which would be that, right? Anywho, Ninth Circuit Appeal petitioner filed, let me slow down. Petitioner timely appealed the U.S. Court of Appeals in the Ninth Circuit. On appeal, petitioner argued that the district court abused its discretion by excluding the expert report, which petitioner viewed as crucial evidence explaining the similarities between the works, and that the court erred in granting summary judgment because substantial similarity should have been a question for a jury, or at least because the court misapplied the legal standard by filtering out too much and overlooking the pattern similarities in sequence and arrangement of events between SKC and P-Valley. The petitioner emphasized that the expert's analysis of 57 specific comparisons between the works, which taken together demonstrate a unique overlap, not explainable by mere coincidence or generic tropes. A video of the 57 side-by-side comparisons is available so because I couldn't do this electronically, I had to just give them the link. The Ninth Circuit panel, judges Susan Graber, Gabrielle P. Sanchez, and Holly A. Thomas, unanimously affirmed the district court in an unpublished memorandum opinion issued on December 16th, which was 10 days after my hearing. And a recording of the circuit, the hearing is available on their YouTube channel. They first addressed excluding the petitioner's expert evidence and its memorandum deposition. The panel held that the district court did not abuse its discretion by striking the expert specialist report and declaration, citing that the Ninth Circuit's precedents, and panel noted, now precedent again is established by wealthy individuals who often win against underfunded plaintiffs. So all this precedent in law is established by people who won cases against much much smaller plaintiffs. Citing the Ninth Circuit's precedent, the panel noted that the trial judge's evidentiary rulings are afforded a high degree of deference, right? The panel agreed that the petitioner's expert restated the same list of alleged similarities that the petitioner already identified, excluding many similarities that were a high level of generality or involved unprotectable elements. The Ninth Circuit in Rice versus Fox Broad, and that's just another case reference, for the proposition, the expert testimony highlighting generic similarities and expressive content does not alter the analysis. The panel further commented that even if there were to consider the expert's report in full, it would not change the outcome of substantial similarity determination under the law. Turning to the merits of substantial similarity, the Ninth Circuit reviewed the summary judgment de novo, and the panel reiterated that the governing standard to prove copyright infringement, a plaintiff must show ownership of a valid copyright, access defendants had to the works, which I have both of those, and substantial similarity between the defendant's works and protected expression in the plaintiff's work. For the similarity prong, in literary and dramatic works, the Ninth Circuit employs an intrinsic and extrinsic test, which here we go with this intrinsic and extrinsic again. The protected expression of plaintiff's works. For the similarity prong, the Ninth Circuit employs intrinsic, extrinsic for summary judgment. The panel proceeded to filter out unprotectable elements of SKC such as general ideas, unprotectable elements of SKC such as general ideas, stock themes, and scenes of fare that naturally flow from the premise of performers in a cabaret club. After filtering, the panel compared the remaining elements of SKC and P-Valley. The Ninth Circuit argued that the district court, let me pause because this is all starting to jumble together. The Ninth Circuit agreed that the district court that the copyright does not protect many purported similarities. For example, the idea of a story about performers at a nightclub, a strip club, is a basic premise and not protectable. Common character types such as ingenue newcomer, a club owner, a rival, or a villain with financial motives, and settings, a neon lit club with a stage, were considered standard fare in this genre. The panel observed, as district court did, that substantial similarities and specific expression of characters, plot, SKC's owner, Tata, facing a homophobic antagonist. I got to bring this up, you guys, because I still can't even see with my glasses. Hold on. The panel observed, as the district court did, substantial similarities in the specific expression of characters and plot. SKC's owner, Tata, faces homophobic antagonists aiming to take over his cabaret by exploiting a moral clause, commandments, whereas in P-Valley, Clifford faces a very different homophobic antagonist, a local politician whose motivations are profit and power, with the threat of coming in the form of a foreclosure and a casino development. The Ninth Circuit noted that the similarities the petitioner asserted were either mischaracterizations or drawn from elements outside of the core works. For instance, comparisons that cited materials left with Lionsgate or themes not directly present in the copyrighted scripts themselves, which is completely untrue. In the end, the panel concluded that whatever random similarities could be found scattered throughout the works, they were not enough, right? And the panel also addressed the petitioner's argument that the combination of the elements. Okay, so here's one other thing, you guys. This is Copyright 101 litigation school, right? Metcalf Botchko was a case where it was established that even if these unprotectable elements, as they would call them, right, which are things that are common in scenes of fare, even if that did occur, that if it was in a certain chronological order, meaning the beginning, the middle, the end, newcomer comes in with a red suitcase, blah, 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 blah. If the timing and the arrangement, selection and arrangement of those common tropes, as they call them, if they were similar, then we would stand a chance, right? However, the panel addressed petitioner's argument regarding the combination of elements. It acknowledged Metcalf-Botchko, allowing a unique selection and arrangement of otherwise common elements to be protectable. However, the panel held that the petitioner had not demonstrated striking similarity in sequence and arrangement that Metcalf did. It found that the order and structure of events in P-Valley and SKC were not closely aligned in a protectable way, aside from broad, abstract parallels. According to the December 16, 2024 Ninth Circuit affirmed grant of summary judgment to the respondents, petitioner's response for rehearing and rehearing en banc was subsequently denied, which is what you have to do before you go to the Supreme Court. Having exhausted her appeals in the lower courts, the petitioner, Nicole Gilbert Daniels, now respectfully petitions this court for review of certiorari. So basically, they threw out the experts report, which said, yeah, the selection and arrangement is pretty much the same as P-Valley. They used overwhelming number of the same things. I said it, the expert said it, I'm the non-movement. But the judges decided, no, we know better. We're more equipped to tell you about this creative process. Now, that's interesting again, because as in the case of Judge Kim McLean Wardlaw, who said judges are not professionals. You are not trained in those areas. You do need an expert's testimony to help explain the difference between a stage play that becomes a derivative work and a dramatic series. And the other part of it is I was never pitching anybody a stage play or a lighthearted musical, which is what one of the appeals court judges insinuated during my appeal. I'm like, and I couldn't say anything, which is why I'm glad I was able to file this writ of certiorari and say this from my own words. I wrote this pro se, you guys. I'm not a lawyer, so don't judge me too hard, but it's pretty good so far, right? Okay, because girl, just listen, I just read my own shit that my lawyers had done and did what I needed to do. But anyway, let's continue. Reasons for granting the writ. This is what's so important and most important for me. Robert P., yes, we're still talking about this, my dear. I have a whole Supreme Court decision coming tomorrow morning at 9:30, baby. And if it's too much for you, go, do a dance, a popular dance, or watch somebody doing a popular dance, or, I don't know, do something more fun and exciting than standing on business with the Supreme Court, okay? Please. Yeah, okay. Reasons for granting the writ. This petition for a writ of certiorari should be granted for 3 independent reasons. First, the lower court's exclusion of petitioner's expert evidence presents an essential question about the role of expert testimony in copyright cases. It implicates fundamental fairness in the adjudication of complex creative works. Second, the Ninth Circuit's decision deepens uncertainty and potential conflict among the circuits regarding a standard for substantial similarity, mainly how combinations of unprotected elements are treated at summary judgment, warranting this court's guidance. Third, the issues raised are of broad significance to authors and entertainment industry, and this case is an excellent vehicle for clarifying the extent of copyright protection for creatives expression in stories and the proper procedures to ensure fair evaluation of infringement claims. Excluding the petitioner's expert testimony presents a serious issue of due process and fairness. The exclusion of petitioner's expert report affirmed by the Ninth Circuit raises serious due process concerns and undermines the proper role of expert analysis in copyright litigation. Expert testimony is often critical in helping juries evaluate nuanced similarities between complex works, especially in cases involving detailed artistic comparisons. By striking this expert's analysis, the court below denied the petitioner a fair opportunity to present her case and improperly assumed that the jury's fact-finding role. As Judge Paez, who is another Ninth Circuit judge, cautioned in Hanagami, summary judgment is not the appropriate stage to resolve questions of creativity and originality. And, as Judge Kozinski noted, determining whether a defendant appropriated protectable expression is a function reserved for the jury. This case offers a significant opportunity for the court to clarify the standards governing expert admissibility, protectable expression, and judicial discretion in copyright cases. You guys, if they grant this, it's going to make life so much easier for so many creatives. But let me continue. Expert analysis is often vital in substantial similarity determinations. Under Federal Rule of Evidence 702, expert testimony is admissible when it helps a trier of fact understand the evidence or determine a fact in an issue of principle. This is especially critical in copyright cases involving complex literary or cinematic works. The Ninth Circuit has consistently recognized in cases like Swersey versus Carey, Zindel versus Fox Searchlight, that expert analysis is not only admissible but often essential in applying the extrinsic test for substantial similarity, particularly to filter out unprotectable elements and focus on original expression. Petitioner, that would be me, Petitioner's expert Robert Aft evaluated 57 specific plot, character structure, and theme parallels between Soul Kitten's Cabaret and P-Valley. Comparisons that would be difficult for a lay observer to identify or assess without expert guidance. By striking this testimony, the lower court does not only departed from the Rule 702 and binding Ninth Circuit precedent, but also deprived petitioner of the necessary interpretive framework to present her case and respond to any defense expert, leaving the fact finder to evaluate technical, creative elements without the benefit of expert context. The exclusion of the petitioner's expert was an abuse of discretion under the circumstances. While trial courts have discretion in evidentiary rulings, the discretion is not boundless. Significantly, when it is exercised, may encroach on a litigant's ability to substantiate her claims. Here, the district court struck the expert report on the view that it merely restated similarities that the petitioner alleged, but the petitioner respectfully submits that this reasoning conflates the report's content with its purpose. Mr. Aft's report did far more than just list similarities. That is my expert, Robert Aft. Mr. Aft's report did far more than just list similarities. It provided context explaining why those similarities were not trivial or random. And it addressed the critical question of whether the shared elements were protected expression or unprotectable ideas. For instance, the expert opined on how the sequence of character introductions in the plot twist in SKC and P-Valley follow an almost parallel structure. The newcomer's arrival, the inherited club backstory, the looming external casino threat, the climactic resolution involving the club's fate. These insights directly counter the defense's contention that any overlap was due to generic tropes. By striking the report, the court prevented this explanation from being part of the record. Notably, there was no claim that Mr. Aft was unqualified or that his methodology was unsound. The exclusion was not based on Dubert or similar reliability challenges. And just to give you guys some perspective, Dubert, whatever it is, was a pharmaceuticals case. So the only reference that creatives have for how you are supposed to act as an expert and how you evaluate something as an expert is based on a pharmaceuticals case, a mathematic scientific analysis. There has not been a case of literature, a literary case, that has defined what an expert report needs to consist of. So we are left to use a pharmaceuticals case to determine whether or not the standard of evaluating was appropriate. So that in and of itself is complicated. It was excluded essentially for perceived redundancy or irrelevance. This is precisely where petitioner believes the court abused its discretion. Given that substantial similarity in this case involved dozens of comparisons, an expert synthesis could help demonstrate the cumulative effect of those similarities, dismissing the expert's contribution and having the same generic similarities. Petitioner alleged ignores that an expert might lend credibility and clarity to those allegations. If an expert independently finds some overlap, that corroboration should bolster, not weaken the case for substantial similarity, especially if the expert can tie those overlaps to protectable elements. The decision to exclude crucial evidence implicates due process at a fundamental level. The petitioner invested significant resources to obtain expert analysis, now as a pro se litigant, no less indicating how vital she viewed this evidence. To have it entirely disregarded curtailed her opportunity to make her case. This case should grant certiorari to consider whether the lower courts applied too restrictive a view of expert evidence in copyright cases, potentially conflicting with Rule 702 and with practice in other circuits. This conflicts with other circuits and improper use of summary judgment. The second question concerning the proper standard of substantial similarity and its application of the summary judgment warrants the court's review due to conflicting approaches among the circuits. While all the courts exclude unprotectable elements like ideas, stock themes, methodology differs significantly. The Second Circuit emphasizes a holistic approach to total concept and feel. You guys, this is technical. Let me get out some of this technical stuff. Get to some of the more meat and potatoes. Sorry, because you guys won't find that too interesting. Ensuring proper balance at copyright. Review is also warranted to address. This is important. Let me go here real quick. I'm not going to bore y'all with the whole thing. The decision below illustrates overfiltering and misapplication of the combination doctrine. Even under the Ninth Circuit's precedent, the panel misapplied substantial similarity standard by overfiltering and ignoring protectability of the selection and arrangement of elements and found the infringement was not isolated components, but in the shared sequence and relationship of events. Petitioner mirrors here. Both SKC and P-Valley feature a young woman with a red suitcase arriving by bus, a gay non-binary club owner battling a homophobic rival tied to the club's past, a plot to take over the club for a casino, stage performances as character exposition, and climax centered around saving the club. While each element alone may be generic, their combined appearance in similar narrative order reflects creative authorship. Yet the lower courts dissected those details microscopically, dismissing differences like gay versus non-binary, and failed to consider whether the overall progression would strike an ordinary observer as substantially similar. Other circuits, like the 11th, weigh the cumulative impact and allow such close calls to reach a jury. This court's review is needed to confirm that originality can lie in the arrangement of common elements, as Feist affirmed. The summary judgment is improper when reasonable jurors could differ on what the overall expression has been unlawfully appropriated. Ensuring proper balance in summary judgment in copyright cases. I'm gonna skim through you guys a little bit and let you know where you can read this for yourself. Review is also warranted to address a broader procedural concern, the balance between filtering out unprotectable content and preserving genuine issues of fact for a jury. While an important tool to dispose of meritless claims, summary judgment must be applied carefully in copyright cases. The court is cautioned that judges should not invade the jury's function by determining how an ordinary observer would view the two works, notably when the works embody creativity and storytelling that can evoke different impressions. There is a tension between the understandable judicial impulse to weed out claims based on similarities or public domain elements and the right of a plaintiff to have a jury decide whether the defendant took the heart of their work. In the present case, the petitioner respectfully maintains that the lower courts went too far regarding filtering out and skepticism, effectively resolving factual inferences against her. Granting certiorari would allow the court to determine and set a standard for appropriate summary judgment in close copyright cases. For example, the court could clarify that if a plaintiff presents a substantial collection of similarities, especially in a similar sequence, courts should be cautious before deciding those similarities non-actionable as a matter of law. This would align with the notion that at some point Quantity and quality of similarities becomes a factual question of impression and emphasis, which is what jurors are for. The substantial similarity issue here is not a one-off. It's not a one-off fact-bound dispute. It implicates a recurring question in copyright litigation in the protection afforded by copyright, and because this case offers an ideal vehicle to address broader concerns. Protecting original storytelling in the entertainment industry. I'm getting to the end of it, you guys. Well, at least I'm going to cut it short. Both Petitioner Soul Kittens Cabaret and Respondents P-Valley explores experiences of Black women and LGBTQ individuals in the context of nightclubs and performance art. These narratives contribute to cultural conversations and have unique creative elements. Petitioner is a relatively small, independent artist known for her work in the R&B group Brownstone under the name Nicci Gilbert, who poured her life experiences and creativity into SKC. P-Valley is a big-budget television series backed by a major entertainment company. The case thus highlights a class dynamic, an individual creator versus a powerful industry player. The legal standards in copyright law mustn't be stacked so high against individuals that potential meritorious claims are dismissed without a full hearing. If indeed P-Valley appropriated core expressive elements from petitioner's work without credit or compensation, failing to address that harm could discourage authors from sharing their works or scripts out of fear that large studios can take the essence of their creations with impunity. On the other hand, if P-Valley was independently created or only drew truly generic concepts, they could be vindicated through the proper fact-finding. The concern here is that with the current doctrine, as it's applied, might allow clever copying of unprotected ideas, but produce a similar aggregate creation. By intervening, this court, the Supreme Court, can reinforce that copyright does protect the original combination and arrangement of ideas into expressive form, thus safeguarding the interest of writers, creatives, whose works might otherwise serve as uncompensated inspiration for profitable derivatives. This case also touches on the role of diverse stories in entertainment. The petitioner's work and the respondents both center around communities and perspectives historically underrepresented in mainstream media. Ensuring robust copyright protections encourages authors from all backgrounds to tell their stories, knowing that the law will protect them from misappropriation. The court's guidance can thus have an implication for innovation and diversity in creative content. We getting there, y'all. Thank y'all for rolling with me. The need for clarity to avoid inconsistent justice. This is important. See, when you go to the Supreme Court, it can't just be they took my stuff and can you relitigate my case? It has to prove that it is going to ultimately help more people than just you, ma'am. So, the fact that petitioner's claim was rejected at summary judgment, while another fact finder might have viewed it differently, and indeed, while members of the public have noticed the similarities. I talked about y'all. Yep, I brought y'all into my case too. I sure did. While members of the public have noticed the similarities and debated them, this indicates the need for clarity in legal standards. From the public and practitioner standpoint, the rules for what count as infringement of a story or a script are somewhat opaque and vary by jurisdiction. This lack of clarity can lead to form shopping and uncertainty. By resolving the questions presented, the court can provide a uniform rule or at least a clear parameter. For example, the threshold of similarity is needed. What is the threshold that's needed to reach a jury, and how courts treat expert evidence in making that determination? Moreover, I keep moving this thing. The appearance of fairness in the judicial process is at stake, right? We talking about whether or not this judicial system is fair. Moreover, the appearance of fairness in the judicial process is at stake. The petitioner proceeding pro se after a trial fought hard to bring her case this far. The perception that her evidence was summarily dismissed, expert thrown out, case decided without a jury, and now she's ordered to pay the respondents a 7-figure settlement that could erode trust in the system's ability to handle a David versus Goliath battle reasonably. The Supreme Court review would show that even pro se and independent creators' grievances are heard at the highest level, reinforcing confidence in the rule of law. And then the end of it is the vehicle statement, whether or not this would be a great vehicle to establish a new law or to establish clarification. This case is an ideal vehicle for resolving pressing legal questions at the intersection of copyright law, expert testimony, and due process. The Ninth Circuit squarely decided the issues. The record is complete and no procedural barriers exist. The core questions are legal, whether the lower courts erred in striking the expert testimony and granting summary judgment in complex infringement case, where substantial similarity turned on the selection and arrangement of the elements. The decision below deepens a growing circuit split and risks sidelining jurors in close fact-finding or fact-intensive splits. Let me say this over. I'm seeing double. The decision below deepens a growing circuit split and risks sidelining juries in close, fact-intensive cases. Without clarification, courts may continue applying inconsistent standards that deny under-resourced creators a fair opportunity to be heard. Granting certiorari would restore balance, affirm the jury's constitutional role, and ensure that copyright law protects original expression without punishing creative overlap. Conclusion: for the foregoing reasons, Dr. Nicole Gilbert Daniels respectfully prays that this petition for writ of certiorari will be granted. Respectfully submitted by Dr. Nicole Gilbert Daniels. So guys, that is my writ of certiorari. You see, that's 32 pages of the writ, and then there are a gang of, hold on, let me see if I can see something right here. So first of all, let me give how about a round of applause? How about a round of applause for me? So I'm proud of myself that I was able to, let me come out of here with this. Let me go to another screen. Here we go. The music bumping. Let me stop it. So I'm proud of myself that I was able to actually get this writ of certiorari done. I'm so grateful to God. I'm so grateful to all of you for sticking around and listening to me break that whole thing down. The Supreme Court is, the last stop, right? If they don't see that I deserved a jury, if they don't see that I represent, the 99% of creatives that never have an opportunity to go forward to trial, it just blows my mind that, if you went by the statistics, if you went based on the statistics, you would not believe that Hollywood ever took ideas from creatives, because creatives just never win. And when I had the opportunity to either go forward and just figure out how to put this thing together, I read a bunch of briefs. I read a bunch of petitions. I read my case over and over. And thankfully, I was able to have someone help me format it, because it's got to be the right font. It's got to be the right everything. You guys, it was a lot. It was overwhelming. And I know that tomorrow morning at 9:30, the court is going to make a decision. And I know that there's a strong possibility that the court will be like, listen, we got way more pressing issues that we're dealing with right now. Their emergency docket is crazy right now. The president has given them a lot of work, a lot of work. But I hope that the little people don't get lost in the sauce. I represent what justice is supposed to be about. I represent what the ability to appeal a decision is supposed to be about. And I just keep hearing the judge in LA saying that he charged me the legal fees and made me pay the legal fees because I had the audacity to take this as far as I did. And it was unnecessary for me to do that. It was excessive. It was too much. I shouldn't have done it. I don't know how you trust a judicial system or a legal system that tells you that because you were standing up for your rights and you have the kind of evidence that I have, you deserve to be crippled for what bankruptcy, 7 to 10 years or some shit like that. Like, you want to bankrupt my family to prove a point that I shouldn't have gone this far. Well, I've gone as far as the Supreme Court, so I took it even farther. And I don't regret it. Like I said, my crown is not tilting because of a system that needs reform. My crown is not, I'm not second guessing myself. Katori did not win shit as far as I'm concerned. She won nothing because we never got a chance to get into the ring. There was never a bell. We didn't go 12 rounds. Shit, we didn't go 1. We didn't go 2. I am bankrupting myself. Kaylee Rose, I sure am. Because I made the decision to pursue freedom and truth. And I'd rather be free and bankrupt than a bubblehead like you looking for clout on TikTok and not understanding the impact of my decision to go full throttle. Clown. I did. Well, actually, you're not a clown because what you're saying is the truth. Because guess what? Catch this tea. They told me if I didn't pursue it, then they wouldn't have pursued the legal fees. So you're absolutely right. And you probably work for them, ma'am. Because who would know that I actually did make the decision to bankrupt myself? So let's just keep it 100. Let's keep it a buck. It was shut the fuck up and let this go. And you don't have to worry about us bankrupting you. Or speak your truth and bankrupt yourself. And that is what I did. So I take full and whole responsibility for that. Kaylee, if that's your name. And we go stand 10 toes down for Nicci. I appreciate you guys in that. Yeah, it's a bunch of bubbleheads out here who just really don't understand what this fight is about. A bunch of cowards who really don't have the backbone to stand with a black woman who has gone all the way to the Supreme Court. And I understand, our community is a little broken in some areas, in some places, and you don't know how impactful my decision to do this is. But I got my husband's permission. I got my 5-year-old grandson's permission, Kaylee. Yeah, that's all right, Nana. I'll figure out another way to get to college. What they did to you was wrong. And you standing on business is important. And I know you're doing it for me and for our future. So Kaylee the clown, that dissertation was for you. I don't regret it. I know I'm going to probably wake up tomorrow and drink my coffee and be a bag of nerves. I'm probably going to toss and turn all night waiting for this decision. But I know what it is. And this is the thing. You will never be able to say I gave up. I'm not giving up. Hey, no way. Baby, this is all about the D, boo. I'm from Detroit. I don't want to rain on this parade. But I'm starting to question the love that was made. I'm not looking for just an affair. I want a love that is based on the truth, not just dare. You will. There you go. So yeah, guys, grateful. Thank you guys for it. I can't say it enough. I got butterflies. I Black Satin said, "Let it go." Y'all better let go of P Valley because that shit ain't coming back. You won't get a season 4. And so let me just rub it in your face. Let me just rub it in your face. You ain't got a season 3 yet, and you probably won't be getting that or a season 4 because God don't like ugly, baby. I ain't letting shit go. I'm putting foot on the gas, and going full throttle into legislation. We're not letting anything go. Oh no. No matter what happens in the Supreme Court tomorrow, we are still going forward. No matter what happens in the Supreme Court, we are still going forward. Talking about let it go. No, don't stop. That was my song. Oh, that's what you're talking about, let it go. Oh, okay. You saying don't. You talking about let it go, sing. Oh, yeah, okay. Would you consider selling your publishing for $300 million? Yes, let's meet tomorrow. Bring cash. I got it. Are you a Libra because of my earrings? No, these earrings are the scales of justice, baby. I'm in the Supreme Court. So I guess I would be a Libra. My husband's a Libra, though. And my sister Alexis and our manager. I'm surrounded by Libras and Aries. Yeah. So, anywho, for those of you who are wondering what a writ of certiorari is, that was it. Very, very proud of myself. I'm very proud of it. And let me just run this little commercial real quick, because this is indeed what we're hoping for. That is until now. I hope it's until now, you guys. I hope that my fight is not, well, I know it's not in vain. I know for sure it's not in vain. Just to give you guys an idea of what happens next, I'm going to take a much needed break. Did you and Katori work together? No, we did not. Tried to, but that was unreasonable. I cannot believe Lionsgate is doing you like this. All that money. Yep. They had every opportunity, you guys. And listen, when companies treat Black women in general like crap, when companies put out narratives in our community that are destructive, just unsubscribe. They losing a lot of subscribers, and that's karma, honey. That is karma, honey. This Fraggle Rock is Fraggle Rocking. What's next? For the first time in if they deny it for the first time in 5 years, I don't have to think about this case anymore. So that's one positive. I can let it go. Because there's, like I said, I do have an option to ask them to reconsider it. I have another expert, thankfully this one is pro bono, who was looking at some inconsistencies and is going to tell me whether or not we should pursue a reconsideration, whether we should pursue asking the Supreme Court to reconsider based on the new evidence that we've come up with or that we've discovered. We discovered the evidence after I filed my writ, so I could not include it in the writ. And, based on research, it was like, just hold it, because if they deny your writ, then you can go back and ask them to reconsider it with the new evidence. So I'm going to use every resource available to me. And if a reconsideration application to the Supreme Court is on the table, I'm definitely going to do that. And then once that happens, it's done, right? And if they grant it, or if they ask for a CFR, which is a call for a response, then I'm going to be real busy preparing to go before the Supreme Court of the United States and argue my case. So this is just me asking them if they will hear it. And again, they got all of these emergency dockets from the President of the United States. They've got all of these very serious issues that they have to decide. So If I can get 4 of them, if I get one judge that expresses interest, I'll get a call for a CFR, or I'll get they'll hold it. If I get 4 judges that say, oh, this needs to go forward, then that's the best news I've gotten in 5 years. That will be the best news my family has gotten in 5 years. But one thing we are accustomed to is getting bad news from the courts. So this won't be a, oh my God, this won't be that. This won't be that. This will be, damn, we knew this motherfucker was a long shot, you know? And I know a lot of people are praying, and I know a lot of people, I heard from my sister Monique and my sisters Aaron, so many amazing, loving people who reached out and just reminded me that they're there. So y'all ain't got to worry about me falling into no dark hole of depression, because, you know, I'm not doing that. But I am going to push my legislation. We have something else that we're launching. I agreed, told the team we will not talk about those things that we're launching until we have a final decision from the Supreme Court. So we are launching some dope sugar honey iced tea. Yes. Don't get it twisted. We still got some goodies. We still got a few magic tricks that we gonna unload for y'all. So nothing changes. That's all it means. Nothing changes. We still keep pressing forward. The only thing that changes is that it is finally, we have come to the conclusion of Gilbert Daniels versus Lionsgate and P Valley. Can you make a mini movie? Yes, we have a documentary film and a book coming. The only reason why the book has not come yet is because I've been waiting for the Supreme Court. Hey, Victoria, I see you. Hello, Columbus. Anyone who has a mind that works to see, you don't get where Miss Nicci is if you don't believe it to be true. Amen. I'll take it. Hey, Soror. I see you, Soror. I see you. God got you. I'm going to take that, Marquita. Absolutely, 100%. Make a movie. Yep, absolutely. You guys, we are still doing curtains. We're still doing the dramatic series curtains. We just decided that it didn't make any sense for us to be trying to cast a show and do that while we're in the middle of this, especially if the Supreme Court grants the writ of certiorari. I'm going to tell you this. If and when the Supreme Court grants certiorari in Gilbert Daniels versus Lionsgate, I'm going to tell y'all what y'all going to see. No, I'm not. I'm not. Just be quiet. Let me just chill out. It's going to be a lot of melanin in that Supreme Court. I'll just tell you that. It's going to be a lot of melanin in that Supreme Court. Anywho, guys, it is 12:30. So I've read it. I'm going to try to get some sleep. I don't know if I'm going to do a Nights with Nicci tomorrow night. It's my bonus daughter's birthday. My husband's birthday is the next day. I think I'm going to take some days off and spend some QT time with family. I had to keep going right after my sister passed. I had to keep going after. We have to keep going. You know, you can't pause. You know, there's no, greatness does not pause for grief. And, but therapy, mental health and wellness, therapist, the gym, eating better, taking good care of yourself, mind, body, and spirit while you are going through hell is very important so that you don't end up tapping out. So that's not the plan. The plan is to continue to go forward. So thank you guys again from the bottom of my heart. I'm so grateful to everybody who's been on this journey with me. I cannot believe that tomorrow marks the end of it or the beginning of it, depending on what the court says. And again, these are the things we praying for tonight, y'all. Just real quick before we get up out of here, let me tell you what we praying for tonight. What we praying for tonight is that tomorrow, when the orders are released, we want to see a grant. We want to see the grant of certiorari. We want to see, if not the grant, the call for a CFR, meaning a call for a response from the respondents. Respondents. Or that it is held. We understand it's a solid possibility that we will see the words deny. Why? because 99% of all writs, especially pro se ones, I think it's even more than 99%, it's like 99.99.9% get denied. So we're not going into this with the expectation of a miracle, but we are going into it with the possibility of a miracle. Please hit like, share, subscribe. We got some great things coming to WIRF.tv. We've held a lot of it pending this decision in the Supreme Court. So 2026 is going to be an incredible year. And what will probably happen is I'll unplug for a minute to regroup from this fight, recharge, and finish editing this documentary film that I'm about to release and finish my book. So the book was on hold pending the Supreme Court decision. And we're going to get that decision tomorrow at 9:30 a.m. So go to supremecourt.gov and either look at the court's orders or Gilbert Daniels. Just search in the docket search, Gilbert Daniels. And you'll be able to read the docket that I just read to you. There's a whole bunch more. The docket is 111 pages. I think I read you 20. So that's how hard your girl been working. And I'm not going to stop working hard for creatives. I'm grateful that the justices in the Supreme Court even took the time to put it in a closed door conference. And I'm hopeful that I get the ability to go forward. So I am your host, Nicci Gilbert Daniels. You have been watching Nights with Nicci. I appreciate you, TikTok. I appreciate you, X. I appreciate you, Facebook. I appreciate you, LinkedIn. I appreciate you, Twitter. I'm sorry. I had it right the first time. I appreciate you, WIRF.tv YouTube channel. Some big things are coming to WIRF.tv YouTube channel. If you have not watched Social Conflict, the short film that we posted, please go to the channel and watch Social Conflict. We got some movies and some TV shows and some R&B Divas holiday specials coming for you guys. Yeah, I got work. Oh, she's booked and busy. I'll see you guys at the Hampton reunion, the Hampton alumni homecoming. I'm sorry. And I will see you at the Tom Joyner cruise, and I will see you in Detroit. Listen, this train is still moving. And guess what? The best part of this whole thing is not Katori can stop pretending like the delays with P-Valley are due to anything other than the fact that this thing was in the Supreme Court. So if you guys get a release date for P-Valley, don't be surprised, because that just means that, you know, they're no longer shaking in their boots about the possibility of having to answer some questions to the Supreme Court. All right. Congratulations to all the actors. Y'all deserve it. Katori and anybody else who had anything to do with taking my concept and my property. Even if we don't get you in the Supreme Court, Karma's going to visit. And she's a bitch. You think I'm a bitch? Oh, Karma's a bitch. And I think you already know that based on the people that are unsubscribing in droves. Yeah, sometimes that's how it happens. Maybe not a direct hit, but come on, Kato. Come say goodnight to the people. Y'all want to say goodnight to my big dog? Babe, let the beast in. Come on, Snuggums. Hi, come on. Hey, say we gonna be all right, even if these people don't give us what we want. All right, you guys, thank y'all for watching. It's Nights with Nicci. I love and appreciate y'all. Please say a prayer for my family tonight. We deserve it. We need it. And hey, who knows? Maybe a miracle will be happening tomorrow. Peace.